standard language that we put in the application in the remarks, which generally is dispositive also, but yeah, thank you, that's very helpful. Okay, applying for naturalization. So again, some of you might know this, but to file the N-400 application, the person, I'm sorry, I just lost my train of thought for a second. Filing for naturalization can take place up to 90 days before completing that 3 or 5 years. I'm going to say 5 for purposes of our conversation. So let's say 4 years and 9 months arrive and the person is really excited to apply for naturalization. The Immigration Service will accept their application up to 90 days prior to the 5-year mark. So how do you determine if or what the operative starting date is? The person should look on their green card and it will say the date that residency was granted, that's the starting date. So 4 years and 9 months after that is the earliest they can apply. Mm-hmm.
How does one get a green card and what kind of time frames versus date of entry into the country and what's going on with getting that?
Yeah, so when someone is approved for permanent residency and let's say they have already been in the United States for a while, usually that takes place through the local immigration office, and in our case that would be Milwaukee. And after they're approved for their green card, the Immigration Service usually takes a few weeks to produce it and send it to the person. If the person is entering the United States as an immigrant, as a new entrant, usually after their entry, again, they have to pay a certain fee in order to ask for the green card to be issued. And then it will be, usually some weeks or sometimes longer for that to arrive in the mail.
But you can apply pretty quick as soon as you get here, almost
Sure.
right away.
Yes.
Yeah.
Sometimes it depends on the manner of entry. Go ahead.
So I don't know about refugee for the asylum, once your case get approved, I guess you need to wait at least for 1 year, you have to be physically present in the US for 1 year. After 1 year you can apply for the green card.
Right, so a person who has gained asylee status does have to wait 1 year to apply for permanent residency. So and there's no 90 days before provision in that scenario. So they have to be an asylee for 12 months and then they can apply for their green card. And then usually, from the time that they apply for it till the time it arrives, probably some months or.
How long this process usually take? Once you apply for a green card, how long does it take to get you permanent residency?
It depends because so many of the processes right now are varied across the United States and even within local offices. So it's really hard for us to predict because we see timelines that are all over the map, so to speak. But generally, it could take some weeks or it could take longer.
Is it kind of first come, first served basis?
Not necessarily, unfortunately. Yeah. Okay. So the USCIS website does have a handy early filing calculator where you can put in the date the green card was issued and the date that you're eligible to apply for naturalization. Also, I'm sure many of you know that the USCIS website has a lot of information about naturalizing. A lot of study guides for people, sample questionnaires, videos on what to expect at the interview, booklets that can be printed out and so on. A lot of good resources, and they're free. So to apply for naturalization, the person would complete an N-400, and they have to file that application. Hi.
Is this is this a Mountain Fox Cities?
Where is the Mountain Fox?
Well, they sent us here.
Oh,
Oh, see.
Yeah, nice to meet
So the N400 is filed with USCIS, and generally for people in this area, those applications are directed to a service center in Arizona and then eventually routed to the Milwaukee office here. The filing fee is $640 for the naturalization application, and then $85 for the biometrics fee, for a total of $725. There are some people who are exempt from the biometrics fee if the person is 75 years of age or older. The fee is non-refundable, so once they send it in, that's it. If they change their mind or if they're found ineligible or something like that, they do not get the filing fee back. Also, I know I'm trying to pack in so much information, I hope you're sticking with me here so far, but I wanted to mention that in the last year or so, there have been a couple of particular policy announcements that I want you to be aware of. One is regarding what are called requests for evidence, or RFEs. So generally speaking, if over the years, if a person has filed an application and maybe something was missing, or the check wasn't written out for the right amount, or they forgot to enclose a copy of both sides of their green card, the Immigration Service typically would send it back and say, with a request for evidence, this is what's wrong with the application submission, excuse me, and this is what you need to do. Try again, And again, depending on the situation, that might be a reality for people, especially if they're trying to do it on their own and they just don't really know everything that's supposed to go into it. Okay, the policy announcement, just one second. The policy announcement indicated recently, or directed the Immigration Service to use its discretion more to deny those types of filings, rather than send a request for evidence saying it's deficient in this way or that way. The Immigration Service has been kind of, in a way, sort of encouraged, by the federal government to just flat out deny those and have the person start over. That doesn't always happen, but they have they can do that. One reason I'm mentioning it is because they would have to submit a new filing fee. If the application were denied, they would have to start all over. Whereas, if they get a request for evidence, they have to satisfy that request for evidence, but they don't have to do a whole new filing fee. So it's just something to keep in mind. Question?
I think if the student applicant doesn't pass the test the first time, they can take it the second time without paying again, but after that, then they have to pay it start over paying it, right?
Right, and I'll talk more about the results after the interview in just a moment.
Okay.
Yep. So this would be kind of just the submitting it by mail stage. Mm-hmm.
Could you define biometrics?
You bet. So biometrics is the Immigration Service's term for doing fingerprints and facial recognition.
Yeah.
So the person will, pay that fee as part of the process, and that goes toward, I guess, staffing the little sub-office at the Milwaukee location that handles doing that. So when the individual sends the application, they'll first get a receipt showing it's in process. Then the next thing that will happen is they will get summoned for biometrics. They'll have an interview date. Usually, if I see some heads nodding, so you're familiar, it will be scheduled, let's say, about 3 weeks or so from the date they get this notice in the mail. And they'll have to go down to Milwaukee, do the fingerprints and facial recognition. And then that is used to do an extensive background check on them to make sure, especially in terms of any criminal history, that they qualify for this benefit. People do not have to be concerned that let's say, if there's something problematic in their background, that going to immigration to do their biometrics is going to result in them being detained or something like that. I mean, that would be very, very rare or unusual. So another thing I want to mention about fees that some of you might be aware of is that the Immigration Service, at least for now, does have the opportunity to entertain fee waivers for certain types of applications. And I say for now because, I mean, anything could change. The government has, really been focusing a lot on people, applicants for immigration benefits having sufficient financial resources. So this whole area of fee waiver eligibility doesn't quite square with overall policy right now when it comes to the government wanting immigrants to show that they have enough money to be here. Mm-hmm.
I'm doing a fee waiver now in 3 categories, and it's usually under the financial hardship.
Okay.
Now, where you have to explain the financial hardship is about 5 lines.
Yeah.
It's not much.
Mm-hmm.
And it also says attach or submit a lot of documentation. Now, this person has a lot of different medical bills and things, so can I just write a separate sheet and attach it to the waiver to explain more, and I'm going to attach the rent bill, the medical bills, the car payment, the loan payment, and all those things as documentation. I've never done one, so I'm just
Right.
I want to make sure it's right. And this person does have a financial hardship.
Okay. So as you mentioned, the fee waiver, the I-912 is used in a variety of contexts. That is to say, people who apply for naturalization and for or one of a list of other benefits can request a waiver of the fee. Not all applications are eligible for a fee waiver, is what I'm trying to say. And to establish eligibility, the government has published a list of income guidelines, basically poverty guidelines that would kind of give an idea of whether somebody is going to be considered eligible. And then the way they prove eligibility is, as you mentioned, based on use of means-tested benefits or based on income. So they're showing, in the first case, maybe food share program enrollment or something like that. In the second instance of income, they're showing copies of their income tax returns. The third possibility is, to explain economic hardship. And as you're mentioning, that can, first of all, with any of the immigration forms, if there is a limited space to include information, yes, you can generally add to that and should in terms of an addendum. That's what what we would do. And yeah, every instance is. Every one of these cases is going to be pretty specific to the individual's income, financial picture and what the hardship is. But yeah, generally what we try to do is look at the income based and use income tax returns. The means tested eligibility ground might be going away very soon because of what I'm mentioning regarding the presidential initiatives around this. Another thing that I will just say generally is that, and I hope that you will understand where I'm coming from on this, there is a lot of room, especially these days, for things to go wrong with these types of applications. I'm not singling you out in any way, I'm so glad you asked the question, but I would just, for all of you and for the folks I work with at Literacy Green Bay too, just offer a word of caution about assisting with forms completion and so on in these quite specific ways, because I understand the interest in helping, and that so many of the people we're working with are of limited resources to be able to hire an attorney or what have you. But you know, because in part of the possibility that the application, you know, could get denied or have, you know, some other, you know, outcome, let's say a request for evidence or, you know, something else that happens at the interview, you know, it would maybe be a good idea to at least give our office a call or have the person, maybe you and the person could come for a consultation together and we can kind of talk through some of these things. You know, again, just to kind of make sure that, you know, you're feeling comfortable with the way the application is being completed and the person isn't relying too much on you for legal advice.
Just that brought up a little interesting question for me. Do they review like the income tax records over the years? I mean, is that part of their process?
Sure. I mean, they do ask, you know, if you have filed income taxes. Also, if, you know, if a person has ever filed income taxes during their period of permanent residency as, you know, a non-resident, then that would maybe indicate to the Immigration Service that the person maybe, you know, wasn't really trying to maintain their permanent residency status if they filed, you know, somehow as a non-resident. Yeah, all of those things come into play, both in terms of determining their
Or if there's any irregularities?
irregularities, good moral character types of issues can often be fleshed out in the income tax context, for sure. Mm-hmm.
Isn't that one of the requirements, is documentation for the N400 is the taxes for the 1040s for the last 5 years? Isn't that what you do, David?
What's that?
Income tax 1040s for the last 5 years go with the
No,
N400?
but the application for the N400 is the last 3 years of your income tax.
Okay.
The waiver asks for the last year of your
Okay.
income tax.
Right, right. And those, I mean, those don't necessarily have to be included affirmatively with the application, but they can certainly be requested at the interview. So,
For instance, if someone missed 2 years of income tax and then went back and talked to the IRS and made a plan and re-established a record over a couple of years, is that going to be held against them?
generally, I mean, something redemptive like that can be very helpful. You know, depending on the circumstances, it might be good to hold off and make sure that all of that happened sort of outside that
Gotcha.
5-year period. It kind of depends.
Mm-hmm.
I'm running out of time, so I
Yeah.
just want to make sure.
5-minute warning.
Yeah, thank you. Make sure, as probably you all know, that the individual keeps a copy of whatever they filed with the Immigration Service and that they go to their biometrics appointment. After filing, they should respond to any requests for evidence if they get one. You know, there's generally a very limited period of time or a deadline by which they must do so. They can check the status of their application using their receipt number, which is on the receipt notice they get from immigration. They can also subscribe to getting notifications electronically. They must notify USCIS of any address change with the form AR11, which is online but can also be printed and submitted in kind of the old-fashioned way. Studying for the English and Civics test, as I said, there are lots of resources at uscis.gov, and I have a feeling your office probably has other resources for studying. It's a great idea, and I'm sure probably many of you already do this, to role play interview questions and answers. And the person should make sure they understand the oath of allegiance, what it means when they are asked to support the Constitution, and other responsibilities of being a U.S. citizen, since that's part of the conclusion of their process. And then before the interview, again, another good reason to keep a copy is to make sure that they review it, that they expect or anticipate the adjudicator is going to walk through everything in that application. If someone works with us or any attorney, the attorney can be in the interview with the person For the most part, we really can't say very much unless there's some need for clarification, something like that, or to argue a legal issue that might come up. But for the most part, it's going to be the adjudicator, asking the individual directly to verify everything that they submitted in their application. If there's any reason to update it, they should do so at that time. Or, to clarify something like, say, they forgot to include some type of citation they got. Before it gets too far into the interview, they should say, I want to make a change to number such and such, and here's, the copy of my paid citation or whatever it might be. There are accommodations for people who have disabilities, like, let's say a hearing impairment or vision impairment, something like that, but usually people are indicating that on their N400 by answering those relevant questions. Generally, interpreters are not needed or permitted because the person is being evaluated on their English skills, but there are situations in which an interpreter, would be needed and would be permitted. This is getting into the weeds a little bit, but exemptions from some of the English requirements would include ones that are based on the person's age plus the number of years they have been a green card holder. I'm gonna just kind of leave that up there and you can read that, but it really just signifies that for people of a certain, I'm now that age, so it's kind of funny, but people of a certain age who've been permanent residents for a pretty long time can be considered exempt from the English test. Generally speaking, they are not going to be exempt from the civics and government test. If they are exempt from the English, they would have to have an interpreter then with them to walk them through the civics and government part of the test. I do want to talk about this. How many of you have gotten questions from people who want to do some type of medical disability exception for the English and civics? Does this come up? Okay. Briefly, if a person can demonstrate by way of what's called an N648 medical certification for disability exceptions, that because of a diagnosed medical disability, they cannot do the English and civics, then they will be considered exempt from that, and they will be evaluated for naturalization based on all the other criteria, all the other eligibility things that we talked about, but they will not be expected to do English and civics. This is a very difficult grant to attain, unfortunately. People have to generally be evaluated by their own doctor, and people may or may not have, a regular practitioner. But unlike the medical exam that is done for permanent residency or green card status, where there's a list of doctors that are approved and the Immigration Service wants you to go to one of those to get the medical exam to become a green card holder, make sure you don't have any certain communicable diseases, that you have all your vaccines. No, in this context, they want an evaluation by somebody who knows your medical history and is willing to fill out a very long form explaining exactly what your diagnosis is and why you are unable to learn English sufficiently or learn U.S. civics and government to pass the exam. Difficulty learning English is not sufficient unless there's a demonstrable nexus between a diagnosed medical disability and that inability to learn English. So if anyone ever has any questions about this, or we want to talk about it in more detail, would be very happy to do so. But unfortunately, I know I talked to a doctor in Green Bay recently who really was looking for some input from me on this, because she said she does see quite a few people who are seeking this exception, but they're their needs maybe can't, I mean, she can't diagnose a particular disability except, that they have, let's say, just because of the circumstances of their lives, have not been able to learn English, let's say, just total, unfamiliarity with the language, maybe persecution and so on, things that affected their ability to learn. The Immigration Service is going to be, thanks for coming, very strict on approving those types of requests. So there are issues that sometimes come up if somebody can't make an appointment. It's obviously very important for them to contact immigration and try to get that rescheduled, which can be done, but it's very critical that the individual, the applicant, take care of that in advance rather than not going, since the application could be denied. Issues can come up at the interview, as I mentioned, that can sometimes kind of steer things in an unfavorable way. Sometimes the case will be continued and the adjudicator will ask for more information, which has to be submitted by mail after the interview. Ultimately, the case can sometimes be denied. And another thing I wanted to mention is this, again, it's a relatively new kind of shift in policy. A lot of denials are going to be subject to a notice to appear. Rather than getting a denial and just think, well, I'll try it again, or I'll just keep being a permanent resident. Depending on the circumstances of the denial, the government could initiate deportation proceedings against that person. So that's another change that is making kind of this entire area just more complicated. Appealing a denial, again, very case specific in terms of whether that's a worthwhile endeavor, but usually that is a very tight timeline of 30 days to do so. Sometimes people can just file a new application and that might be a better avenue. After the approval, if they are approved, they have their oath ceremony, as a lot of you know. They get a certificate of naturalization. They can sometimes have the oath ceremony somewhere in this part of the state, but usually it's in Milwaukee. And then many people, try to apply for a U.S. passport as soon as possible. I wanted to mention this, that in addition to the other things that we've talked about having changed in the last year or two, you might have heard that the government has been looking to denaturalize people who they think that they're now going to determine did not deserve to be naturalized or naturalized based on fraud. We don't really know how widespread or organized this initiative is on the part of the government, but it is something that we are seeing news reports of and so on. So I know we had some questions along the way and we're beyond time, so I want to thank you very much for your attention. I know it's a ton of information, and just that I really, really give you all a lot of credit for the support and friendship and education that you are offering to the people you work with. I know that in our communities, the immigrants we're working with are up against a lot, and your support, I'm sure, is really invaluable to them. So thank you. If you'd like to receive our firm newsletter occasionally, please feel free to sign up on my legal pad, just name and email, and then my business cards are available if you should want to give me a call and ask me a question or have someone contact us for a consult. I'd be very happy to help. So thank you. Thanks a lot.